Today, a new statement of changes has been published to the immigration rules. Today is 14th of October 2025. I'll start with giving the summary of the changes which I've got. It has come to my email today only in the afternoon, about 2 hours ago. So I'll go through the summary and then I'll go in details. Firstly, summary of the key changes supporting highly skilled migration. So there are some very important changes that were they had proposed in the white paper, and they have been made. So some of the important ones: high potential individual uh, visa expansion. The number of eligible universities, HPI, it's a very small area. It's used quite less. It's similar to graduate route, where graduates of individuals who have graduated not from a UK university but from outside the UK. Mainly, most of the universities on that are American universities, and there are some other countries' universities, but almost I would say 80% are American universities. If you have graduated from one of those universities, then you can apply similar to a graduate route called as HPI, high potential individual. It's not used that much, but this is an area. The number of eligible universities is being expanded. This was the problem. There were very less universities. Now they are expanding the number of universities from which any individual who has graduated outside the UK they can apply. It's exactly similar to a graduate route. Only thing is they study in an outside UK university. Expanded to include international institutions ranked in the top 100, with a cap of 8,000 applications per year. So there are 8,000 applications cap is there. For graduate route there is no cap, just a comparison. And this change is going to happen from 4th of November 2025. 4th November 2025. HPI, a very short area, not that famous, but yeah, it is in the immigration rules. Secondly, global talent visa enhancements, expansion of the prestigious list and evidential requirements for architects. This is also a small area, not much explored. It's not very common that everyone would be interested in, but yeah, they are just increasing expansion of the prestigious list, prize list. So there are some prizes. If you got them, let's say an Oscar award or something, then that qualifies you directly to apply for a global talent visa just on the basis of that award. Just to summarily to tell you, so they've increased, expanded the list of approved awards or prestigious prizes. So you just apply without an endorsement and get a global talent visa. That's how it is. That change is coming from 11th of November 2025. So that is the second change that is coming in. Okay, now the next one that I have here is student transition to Innovator founder visa. Students who have Students who have completed their course can establish their business while transitioning to this visa. So I'll go in detail as I go through the changes. This is a summary. Students who are going to apply for an Innovator founder visa. Innovator founder visa is another area which is very less explored. Not It doesn't make sense even going on to that visa, because getting to ILR from that permission becomes is almost impossible for almost 90% of the candidates. There are other challenges I may have discussed in other videos, but summarily, any student who is going to go on to that Innovator founder visa, many Innovator founders, once they are on that, subsequently they feel stuck and then they move themselves to skilled worker and then try to complete and get ILR. That's what they do, but that is a less used area. Home Office is trying to improve on these areas where they are less used, or there are challenges, applicants are not applying. There are many challenges of them, so they are trying to change the HPI, high potential individual, global talent, and the prize list and all. Student transitioning to Innovator founder, students who have completed the course of study, the course completion is still there. I know people may ask, can students directly go? No, they cannot. Again, they will put the course completion aspect, can establish their business while transitioning to this visa. It's not a straightforward one. I know it says starting a business and all. It's not like the old entrepreneur visa. It has its own challenges. I have a detailed video where I've explained what is an Innovator founder visa. If you search on the channel, you will get it. Innovator founder visa. Uh, Tighter controls in immigration system. So this is where this is the area which is going to affect the most individuals that are watching this video. Graduate visa, graduate route visa. I think in the past also I have made several videos where this change might almost render the graduate visa quite ineffective, or the demand for it will go quite less, and it may affect further student admissions in future. This was proposed Graduate visa reform reduced from 2 years to 18 months for most. So, except the PhD graduates, the PhD graduates are protected, they get 3 years. But other graduates, masters or bachelors or whoever is trying to get a graduate route visa, they would only get 18 months. Yeah, and this change is coming where the date of application of the graduate route permission is from 1st January 2027 onwards. Yeah, applies to application from, it's quite a long period, so they are trying to give opportunity to students to decide before they come to the UK. So that is the goal. It looks like they could have changed it from next year 1st Jan 2026, but they haven't done that. So in my opinion, most of the students who are already in the UK, they should, who are already in the UK and studying and expecting a graduate route for 2 years, I think they should qualify, because this change is coming from 1st of January 2027, which is more than a year from now. So we are already in October, November, December, 1 year and 2 months from now. So most of the students will complete their course of study maybe by December, January, or by next September before, and then they will apply and they will get the 2 years. This change is usually coming for the new batches that are coming in, looks like to me. So graduate route visa reduced to 18 months, but that is happening from January 2027. The date of application for the graduate route visa should be on or after 1st of January 2027, then the 18 months. Before that, I know people will ask me on the channel, before that anyone applies, even on 31st December 2026, you will get a 2-year graduate route permission. PhD people, they will still get 3 years. That is not changing either now or later. English language requirements raised to level B2 for skilled workers. English language, yes, everyone has been waiting for this, from B1 in all four components. So if you want to apply for a skilled worker visa, for example, then you need to give all four components: reading, writing, speaking, and whatever, yeah, listening. So all four components you need to pass. That is different from a family visa, for example, or if you are applying for citizenship on, or you would need only a level which is speaking and listening. You go and sit and you talk to the person, that's speaking and listening, which is a very quite a lower level. But on skilled worker, they require a B2 level. It was B1 before, now it is increased to B2. It would be an intermediate level. That's what I expect. B2 level for skilled worker visa whoever is applying HPI scale up visas. When is that changing? The date of application is from 8th of January 2026. So it's very short. We are in October, November, December, and January. In about less than 3 months from today, 8th of January 2026, you will need, if your date of application for a skilled worker visa, skilled worker is the most one in demand. HPI and scale up are also there, not much used. But if you are applying for, let's say, a skilled worker visa, the date of application when you make the fees payment, the visa fees, IHS, and the visa fees payment is the date of application. It's from 8th of January 2026. Then you would require a B2 English language requirement. Usually, this will not affect someone who is trying to uh, usually people use, I have seen from other countries, mainly from India, etc. If you have an education like an MBA or an engineering or something, if you are trying to get an equivalency certificate from ACTIS, ENIC, whatever you call that, those bodies, yeah, then they usually say C1 is the level of English. That's what I've seen. I mean, so they would they would not be impacted. That's my calculation. That's what it says. Every time I've seen an NX certificate, every time they say definitely C level, which is higher than B2. C1 is what I've seen, or more than that. So B2, they will not have any issues meeting this. If they're using the same NIC requirement, then it should be fine. Second part, anyone who's already on a skilled worker visa, these are the questions that will come on the channel. So I am clarifying this. It is not here, but I know I've read the rules. Anyone who's already on a skilled worker visa before this date, if they are extending their permission, then in that case they don't need the B2 level. Their B1 is already used for their previous skilled worker or healthcare visa, or whatever that is, skilled worker variant. In that case, they can extend, change employers, do whatever. They don't need a B2 because they've already met the requirement in a previous application. So yes, existing skilled workers not affected. Anyone applying for the skilled worker route for the first time, on or after 8th of January 2026. They will be impacted. They need to pass B2 in all four components. Suitability requirements for family and private life. General grounds for refusal now apply, ensuring higher standards of good character. I'll go in detail when I see that. Slight changes to the suitability requirements. I think it is more on overstay and all of that. Additional measures, immigration skills charge, which was already promised that they are going to change, and immigration skills charge increase. A separate process will increase the charge by 32% to encourage investment in British workers and reduce reliance on overseas recruitment. So immigration skills charge is going to increase by 32%. I've addressed this in various previous videos. So that is happening finally. Settlement consultation, publication of earned settlement and citizenship consultation expected later in 2025. They have not changed anything. I know people will ask me 10-year ILR, 10-year citizenship, all those things, that is still in discussion. Now the only thing that the government is saying, the consultation process will begin. Publication of the earned settlement and citizenship consultation expected later in 2025. Later means, what is the latest? We are already in October, maybe December. That's what I'm predicting. The consultation will begin to think about how to make the rules for 10-year of that ILR that people are talking of, skilled worker ILR, and even citizenship, making it 10 years, earned settlement, earned citizenship, etc., etc. Nothing is changing. I know questions will come. These rules are not changing anything to that. They are only saying we will begin the consultation in December, April, later 2025. I know they mean December 2025. It's about one or two, maybe just one after 1 month, or maybe November. That's it. But the consultation will begin. That will go for long. The rules are not expected to change from our calculations, from my calculations, and other lawyers also, not before April 2026. Whatever the rules come, if they come. Preventing illegal working. Also, another question that people ask, existing skilled workers may not be impacted. That is what we are calculating, and that is what we expect. It has never happened, but yes, I don't want to comment on that yet. But the consultation will begin, and then we will see how the rules are changed. Preventing illegal working. Later this month, the Home Office will launch a 6-week public consultation on extending right to work checks to cover a wide range of working arrangements. They're going to come up with something to stop illegal workers from working. E-visa transition. This is another one. Most entry clearance. So I'll explain here. In mid-July, we removed. So Home Office has removed 90-day entry clearance stickers. Anyone who applies outside UK, let's say for a skilled worker visa, student visa, whatever, they would get a 90-day sticker called as vignette, entry clearance vignette, from most main applicants on work and study routes. So in mid-July, they stopped it for student route, skilled worker route, main applicants who are applying. The next phase of change that is coming is they don't get stickers, they get an e-visa. They create their e-visa account and all of that. The next phase, starting in the coming weeks from now, will extend this to most main applicants on non-study, non-work and study routes. Non-work would be, let's say, maybe family route visa, spouse visa, partner visa, outside UK only. This is, I'm only talking of outside UK entry clearance applications. Study routes, maybe dependents of study visas and their dependents, uh, as well as dependents of those included in the first base, and also dependents of skilled worker visa holders, dependents of students, maybe spouse visas, partner visas, etc., etc. So they are trying to bring, they are going to stop that vignette, the sticker, for 90 days, and e-visas will be by default. That's what will be started in the coming weeks. That's what they say. Now let me go into some details what I have over here. Okay, so I'll go in the order what the changes they are proposing. Introduction of a visit visa requirement for nationals of Botswana. So Botswana, they will be required. They are a non-visa national, looks like. That's why they are asking Botswana nationals to apply for a visit visa now. These small changes keep on happening. Recognition of Palestine, changes to the visa national list. Palestine has been recognized as a state and has been added to requiring a visa national list. Anyone visiting from Palestine has to apply for a visitor visa. Summarily, that's what it means. Other small changes, German school groups travel, easing travel requirements for German school groups to visit the UK. Uh, let us go in the details and I will explain that. So anyone in studying in a school in Germany. It's mainly for European nationals aged under 18 years who are studying. They don't need an ETA or something. They can just travel without an ETA if they are coming as a school party or something summarily. Doesn't affect majority of the migrants. Changes to the validity requirements in appendix temporary permission to stay as a victims of human trafficking or slavery. So in this one, what is changing? There are two types of applications that are allowed, FLRHRO and another application made directly to the competent authority. This also doesn't affect much people. I'll try to go to the main changes. Some changes to statelessness aspect. English language requirement. This will affect a lot of individuals. As set out in the immigration white paper, we are introducing new requirements for English language. The English language requirement for skilled worker, high potential individual, and scale up routes is increased to from B1 level to B2 level as defined in the CEFR. So that's what I said before. The new requirements will apply to those seeking an initial grant of leave in a relevant route. Either you are switching inside the UK, let's say you were on a spouse visa and now you want to switch for whatever reason, your relationship is ending or something, or any other reason, you are switching from a spouse visa to a skilled worker visa, then and you are filing that application on or after 8th of January 2026, you would need a B2 level in all four components. Or if you are anyone who is filing from outside the UK from on or after 8th of January 2026. So the new requirements will apply to those seeking an initial grant of leave. Grant of leave means it can be inside the UK or outside the UK in a relevant route. The relevant routes are scale up, HPI, high potential individual, and skilled worker. Following the implementation of these on 8th of January 2026, those who have already obtained permission, so this is what I explained before, where they were required to show a B1 test, will continue to be subject to B1 level requirement where they are seeking an extension on the same route. This is what means a skilled worker who already has a skilled worker visa, they are not required to do B2, they can continue to have that B1 that they have met. Okay, next. High potential individual, which I already said, yes, they are increasing the number of universities. Change to reduce the duration of stay. This is the important one. Many individuals will be interested in this. Graduate route to 18 months. The immigration white paper published on 12th of May announced the government's intention to reduce the duration of stay under the graduate route to 18 months. This was already proposed, now it is coming into the law, but effective quite far in the future. So currently students in the UK should not worry. Most of them, I don't think 99% would not be affected with this. They would complete their course of study well before this and apply for their graduate permissions. The graduate route currently allows eligible graduates who successfully complete a UK bachelor's degree or a master's degree or the relevant qualification to remain for 2 years and PhD graduates to remain for 3 years. The change to 18 months will apply to applications submitted on or after 1st January 2027, more than a year from now. With PhD graduates continue to receive 3 years of leave. PhD graduates are not touched, they will continue 3 years only, nothing changing for PhD graduates. The data shows the reason the government is giving is that too many graduates allowed to stay in the UK following the successful completion of their studies are not moving on to graduate level roles. So that has been seen from data. So graduates are not taking graduate level roles, they are taking lower level roles, something like that, which the graduate route was created to facilitate. That was the goal, but that is not happening. So they are reducing it to 18 months. I don't know how that is going to change. Yeah, so suddenly graduates will start taking graduate level roles because it is 18 months now. I don't know what is the rationale behind this, but yeah, rules change without any rationale. Okay, so it is important that those who stay transition into graduate level jobs and are properly contributing to the economy. Rather, if they would have kept it to 24 months, the individual would have paid taxes for further 6 months and worked anywhere, even if that was not a graduate level job. So I don't know, it would be less contribution to the taxes, but yeah, that's just my opinion on it. Okay, students transitioning to innovator founder route. This is a specific change to student work conditions uh, that will allow student visa holders to establish a business. Yeah, this is not changing. I know you will see YouTube reels and videos, and everywhere people will start. I don't know who makes those viral videos where they will say students can start a business in the UK now. New rules came into play. It's not that easy. So this is what it is saying: student visa holders to establish a business where they can have completed their course and are switching to innovator founder route. It replaces a similar provision that previously applied to those switching into the startup route, which is now closed to new applications. So their goal is to just allow students to switch into the innovator founder route. There are several challenges of innovator founder route. I have made a blog post also of that. If you go on the website, you will see it. I think it was just 1 week before or so, 1 or 2 weeks before. Mainly, we all lawyers have summarized it and discussed it, and that's what those are most of the main challenges of the innovator founder. Mainly, getting an ILR after getting an innovator founder is quite challenging. Uh, that is one of the most challenges that it looks like. And secondly, even the endorsing bodies, yes, to found the endorsing bodies on the innovator founder route, they also expect individuals to complete 5 years to get ILR. I know in the rules it will say within 3 years you will get ILR, but to meet those requirements, almost 99.99% individuals cannot meet those requirements, and most of them try to switch to skilled worker and try to get ILR under the skilled worker subsequently. So it has its own challenges. Read that blog and you will get an idea. It is on the website. So what else? Yeah, I may link it down below. Yeah, so change to replace. So summarily what is changing is student work conditions that will allow student visa holders to establish a business after they've completed the course of study and they are establish a business and move on to an innovator founder. How it is going to happen in practicality, we need to wait and watch, because once abuse starts, home office starts beating up and stops whatever the intentions were. So grounds for refusal with part suitability. Yeah, part 9. So this is an important one. Part 9 has been replaced by a new section called part suitability, which serves, so this is the grounds for refusal of applications, that is the part 9 thing, which serves as the central reference point for all suitability related refusals and cancellation grounds, where you apply for a visa and it is refused or your permission is cancelled on suitability grounds. This change aligns with terminology already used in simplified immigration routes, where applicants are assessed uh, against suitability requirements rather than grounds for refusal. Part 39E. So 39E is very important. People use this. So if you see, if a skilled worker, graduate route, student visa, any application is refused and you make an out of time application, this is the most common use of part 39, where you make an out of time application. Let's say my application is refused, a skilled worker or anything, graduate route or student visa. Within 14 days of the refusal or rejection as invalid of that application, I can make another eligible application which will be considered for a decision. No doubt that application is out of time. I think I've made another short explaining this aspect. But 39E they are bringing into the suitability area. It was outside. I think that's what they are doing. Where summary, this is what I think. This will be held against you if they want to on good character aspect, because suitability goes on good character. How it will be used in practice, we have to wait and watch. But this is what it looks like. Part 39E, where you can make an out of time application, okay, and it will be considered for a decision within 14 days of application refusal, administrative review refusal, appeal refusal, any refusals, uh, or invalidity or decision of an application. Part 39E, which sets out exceptions for individuals who have overstayed their permission. Overstayed means within that 14 days, that's an overstay, has moved into part suitability under a dedicated section, exceptions for overstayers. So it was outside, it has been got into suitability aspect called as part suitability. This ensures that overstaying exceptions, they are giving you an exception and considering your application, are considered within the broader suitability framework. So that is also one of the aspects which would be considered for suitability, whether you are a suitable candidate, you are meeting, let's say suitability would be you, whatever, you have a criminal conviction, let's say, or you have a driving without insurance conviction, that's a conviction, yeah, it stays, you don't get ILR for some period, or those are or driving under the influence, whatever, alcohol or something. So these are serious ones. I'm just taking that as example. So they fall under suitability for citizenship and usually ILRs and all. In the same way, maybe 39E, that overstay that they allowed you to apply an application within 14 days of your rejection, that was an overstay. It never went into a suitability area. They never thought when they were deciding on citizenship or say any other application, oh, he made an out of time application. Is he suitable or not? But this 39 is going under suitability, and this will also be one of the factors. That's what I summarily see what they're trying to write here for deciding whether you are a suitable candidate or not. Not as high as a credential as a criminal conviction, but yes, suitability. Overstay comes under suitability. You overstayed, that it works against you. You made frivolous applications, which I always say in my other videos. Don't file those FLR applications, that is a frivolous application to buy time. Don't file those set P applications, that is a frivolous application. Set P is for settlement for refugees. Similar of those, that is also, that goes under your suitability. So this 39E, where you are allowed to make an application, a valid application within 14 days of overstay. It's an overstay, basically it's an out of time. That will also go under suitability. How it is going to be affected in practice, we need to wait and see. How hard are they going to look at it? But I don't think it should affect that much. They just moved it because they don't want to see an abuse on that area. Yeah, a number of constitutional changes. Part 9, okay. Amendments to Appendix FM, Appendix Private Life, Appendix Adult Dependents. So this is all family root area. FM, family members, private life. Uh, then private life is 20-year private life, 10-year private life, any private life rather. Adult dependent relatives, settlement, family life to apply part suitability. So what is happening over here? So, family and private life rules have until now not applied Part 9 grounds for refusal, which apply, let's say, for a skilled worker ILR or skilled worker application or student visa. That's Part 9 grounds of refusal. But family and private life had their own. Instead, they had their own suitability requirements, which have resulted in a more generous. Family and private life suitability requirements are more generous. For example, you have overstayed in the UK maybe 7 years. We have done those applications, 10 years and all. And then you go outside the UK, you marry a British citizen. You can, if even if you marry outside or inside, doesn't matter. You married a British citizen, and then you apply for a spouse visa. And if your relationship is genuine, Home Office has to overlook that 7 years or 10 years of overstay. On the contrary, if you stay overstay for 10 years and then apply for a skilled worker, it has repercussions. It has ban period, all of those things. So that is what I mean. Family route has always been very generous on suitability. There is a different suitability for family route, spouse visa, parent visa, child visa, all of that stuff. Uh, yeah, the adult dependent relative, etc., etc. So now what they are changing is, which has resulted in a more generous approach where there are suitability considerations. Let's say you overstayed for 10 years. It is a suitability consideration on skilled worker, but then why is it not on a spouse visa? That was the difference before. This amendment will apply common suitability provisions to, so the same suitability provision looks like what they are saying, that would apply to a skilled worker or a student would apply to a spouse visa application also. This amendment will apply common suitability provisions to the family and private life, deleting the suitability for, so there were two suitability requirements summarily, one for everyone else and one for family areas, family routes, spouse visa, etc. The family route area, they are deleting it completely. The common one will apply to everyone now, even the family one. So that's what they mean. So we spoke to family and private life and applying part suitability, that will be removed, and the common one will apply to family and private life as well. So it is interesting to note that this may affect, we have to see how it works out in practice, because we have been doing applications. I know everyone does it. We also do it where, as I said in my example, someone who has overstayed in the UK for 7 years, 10 years, goes outside and then makes a valid spouse visa application, comes back the next month. That's it. Immediately they can go and apply. There is no ban under the family route area. But they may start banning them, and the ban period, for example, if you overstayed for more than 3 months in the UK, okay, 7 years, let's say, and you left at your own expense, you may be banned for 12 months. It will be interesting to see how it applies in practice, because let's say if you are married to a British citizen or you are going to get married, you will be separated from that person for 12 months. Maybe that's how they will be applying it, because if this doesn't apply, then the by default provisions apply. We will see how it goes in practice, and there may be case laws and all, and that may be challenged in the courts, but we will see that as it comes. So overstayers may have challenge applying from outside the UK. That's what I foresee from what they are writing now. But then once the rules come in properly, we will see from experience and all. Changes to appendix temporary work, seasonal worker is another small area maybe, or big area. Changes are being made to the rules concerning the number of months a seasonal worker must be outside the UK before being permitted to apply for a new seasonal worker. These changes will permit seasonal workers to spend no more than 6 months working in the UK during any rolling 10-month period rather than any rolling 12-month period under the previous rules. So in any 12-month period, a seasonal worker can only come. In any 10-month period, uh, a seasonal worker can only spend 6 months in the UK as a seasonal worker, and then so kind of a cooling off period. That's how they are looking at it. Yeah, seasonal work was another area which was abused. I know many times I also get questions on the channel, etc., where seasonal workers usually want to change to a skilled worker or a long-term permission, but then that is what they are stopping. They stopped it in many areas. I know seasonal worker they also took out from 10-year long residence. They took out from several areas. I know they don't allow switching from skilled seasonal worker, etc. This is a problem area. Anytime problems come, they try to take them out from every area. This is what is happening for seasonal worker. Yeah, they've stopped them. They don't allow them switching into any long-term route inside the UK. Now they're also not letting them in a 10-month block. They can only spend maximum 6 months and then go back and have the whole 10-month block, maybe 4 months outside, and only then come back for further 6 months, something like that. Changes to the Ukraine permission extension scheme. The Ukraine permission extension scheme was launched 4th February. They give all summary. What is that is happening? As part of the ongoing measures, we have identified a need to allow for child's permission to be aligned to that of the legal guardian. As such, we are updating the UPE. It's a specific area for the Ukraine nationals. Eligibility requirements to ensure children can be granted permission in line. There was some disconnect, so children will be granted in line with their legal guardian. As an additional safeguarding measure in the eligibility requirements, we are specifying that adult parent or legal guardian must be in the UK for the child's permission to be aligned. So the adult guardian should be in the UK for the child to be aligned. Sometimes if they travel outside the UK, then they will not align the child's permission if the adult is not in the UK. We are also amending the residence requirement. This is also specifically for Ukraine scheme only. To allow an application to be refused where a child born in the UK or Islands, Jersey, Guernsey, Isle of Man, to a Ukraine national parent who holds or is eligible for Ukraine scheme permission has been outside the UK or Islands since the birth. So if the a child born, the parent had a permission, Ukraine permission, the child was born, and the parent left the UK and spent time outside the UK since birth, then they would cancel the permission. We will amend refuse where a child is born. So they would allow an application to be refused. So they would refuse the child's application for further permission. Lastly, we are making minor drafting changes. They don't want the abuse of this scheme. That's why they took out the Ukraine permission also from the 10-year long residence. If you are on Ukraine permission and you're planning to get 10-year long residence, that Ukraine permission will break your continuity of residence. This will be challenged in the courts and all. There are different reasons for that, but yeah, that is something that is to be seen. But yeah, Ukraine permission was a temporary permission. That's what the government says. And once Ukraine gets back, then all the citizens should go back. That is the goal of the government. That's the reason they are making it more and more strict. If people are leaving and then again trying to come back to the UK, making it hard for them. That's a summary of why they are making this. Changes to Abednik's global talent. So the global talent category is for talented and promising individuals. Yeah, this is what I said. So there's a small change that I summarily discussed before. Let me just say in one line. As agreed, Arts Council England and their sub-endorsing body, Royal Institute RIBA of British Architects, we are expanding some requirements to allow individuals within the architectural field to provide evidence of their achievements as a named member of a group or contributor, as well as this is a very niche area for architects. Uh, as well as for their work as an individual. Additionally, we are allowing applicants to provide evidence of significantly contributing of being shortlisted. Yeah, they're just improving on that architectural aspect. I know there were some challenges. Yeah, I've addressed it in a specific video somewhere. I know. Let's not get into the detail, but yeah, they're trying to simplify that aspect of architects. Global talent prestigious prizes, yeah, they are increasing the list of prizes that would allow you to get a global talent visa. Further 27 prizes has been added to the list, and one prize has been deleted. That's it. Very niche area. Changes to the EU settlement scheme. Let's see. The USS in Appendix EU enables EU or the European. Okay, this is a summary of this. Changes clarify that drafting of change made from 16 July, enabling a holder of pre-settled status under the USS to be granted settled status where they have been resident in the UK for at least 30 months in total. Yeah, this was change made from 16th of July 2025. I'll just summarily state this. They've made it very easy for someone who has pre-settled status under the EUSS. This may, yeah, this will apply in a way. Earlier, anyone who has pre-settled status was required to spend 5 years of residence, and in the 5 years, the 12-month rule of a skilled worker would apply. In any 12-month cycle, you cannot be out of the UK for more than 180 days. Now that has been reduced. Now they are saying in the whole 5 years, a pre-settled status holder spends in the UK. Of the 60 months, at least 30 months they should have been resident in the UK. And they can start the qualifying period even now. Most of the pre-settled holders, almost who are eligible, who have not got the pre-settled status in error or their pre-settled status has not been curtailed, for them, everyone is getting a 5-year extension this year also. They can start their residence period if they want to complete this 30 months even from this point forward. Earlier it was restrictive. Your qualifying period would only begin before 31st of December 2020, the end of the Brexit transition period. But now they say any 30 months in either in the previous 5 years of your pre-settled or the next 5 years of your pre-settled, which has been automatically extended. So that is a simplification. So, enabling a pre-settled status holder under the EUSS to be granted settled status where they have been resident in the UK for at least 30 months in total in the most recent 60-month period whenever they apply. They may be applying after 5 years or now. In the most recent 60-month period, they will see at least for 30 months you were a resident in the UK, prove it, all the documentation, and that's it. They will do the automated checks to your NI number, DWP records for benefits, etc. If they don't find anything, then you may have to provide further evidence, council tax, bank statements, payslips, P60s, whatever you have. They also bring the grounds for cancelling pre-sale status on or before the holder's arrival in the UK into line with those curtailing it in country, so that where proportionate, this can be based on the fact that the person never met as well as where they have ceased to meet the requirements of Appendix EU. So this is about curtailment. They have started curtailing pre-settled status which was granted in error. I had made another video about this cancelling of status, but just to simplify, uh, I had a consultation today only where the individual, I think husband wife, they are from Bulgaria. They applied for the EU settlement scheme, maybe through an agent or something. They were never resident before 31st December 2020. So they never qualified for the pre-settled status. Maybe the agent used some fraudulent NHS letters or something, or maybe put their names on it. Now, after 4.5 years, they've spent 4.5 years in the UK. They have two children. Yeah, they both are under 18, and they have their life in the UK. Home Office have sent them a letter to the wife and they have cancelled. They said, give reasons why we should not curtail or give us evidence that you were resident before 31st December 2020. If you have got your pre-settled status in error, Home Office has started cancelling those pre-settled status. They are curtailing, they are giving you some period of time to give evidence if you have any other proof. If you don't provide that, they are sending a curtailment letter and they are curtailing. However, that curtailment is subject to an appeal right. So in that case also, children may have family rights, etc. They've already living in the UK for 4.5 years. If they continue living in 7 years, they may get their own rights of private life and all. There are different ways. So if you are getting such letters, yes, you can consult us. Consultation links will be there in this video, other videos also. So if you are getting the curtailment email, take it seriously and reply to that. Give whatever information it is. If not, it will be cancelled your status, and you should appeal, or your all your work rights, benefits rights will end. If sometimes it's not your mistake, agents have done something wrong, but that is what is happening. Home Office is actively cancelling pre-settled statuses of individuals. And what this rule says, the pre-settled status, someone who is outside, so they are also bringing the grounds for cancelling pre-settled status on or before the holders arrive in the UK. Let's say you were outside the UK and you got pre-settled status. Before your arrival only, Home Office can cancel that pre-settled status if it was given by mistake, in error, or with a fraudulent document that was produced. They can do that. Deletion of obsolete immigration rules, tier 1 entrepreneur visa, so that has already gone. They are just deleting that from the rules. Tier 1 entrepreneur, long gone, rest in peace. Appending sports governing bodies, these changes reflect, yeah, British Kendo Association, Great Britain Wheelchair. These are small areas to become Home Office approved sports governing bodies. Two sports governing bodies are added. Changes to appendix government authorized exchange schemes. These are usually students use this to get internships, etc. in the UK. These changes update the names of two visa schemes following requests from the endorsing government departments, the Ministry of Justice and Department for Business and Trade of each scheme. These changes will also delete the Khebrat Leadership and for Change program scheme endorsed by the Department for Education, as the scheme is no longer in use. Small changes to that area. Uh, Changes to appendix child student safeguarding. Yeah, this child student safeguarding is also changing. A nominated guardian is a carer. Many students come and they bring their children with them. Currently, only dependents that are allowed are if you are doing either a PhD course or a master's that has research based something. Not all students can bring their dependents. A nominated guardian is a carer that looks after a child for less than 28 continuous days and is not a close relative. The definition of nominated guardian in the introduction section of the immigration rules requires the length of care to be less than 28 days. This has been amended to clarify that 28 days must be continuous days, so the guardian should look after the child for continuously 28 days. The definition has also been expanded to include guardians that care for child students during periods of term time. So the other changes, these were already proposed for the guardians, etc. The living arrangement requirement has been amended to clarify the permitted living arrangements on the route, including that as a boarding student. Is mainly for children who are coming as a child student. Yeah, it's a child student, not a normal student. I got confused over there. Child student is someone who is coming to a private school or something. They also get a CS. They study in a school. Uh, Usually it is common with private schools, they give sponsorship to students and students come to study. They are under 18 and it's called as a child student permission. In that case, the living arrangement requirement has been amended to clarify the permitted living arrangement on the route, including that as a boarding student you are able to stay with parent who has permission as a parent of a child if the child student is over 12 years of age and the parent is caring for the younger sibling who holds permission as a child student. So these are all the changes happening on that child student area for their safeguarding requirements. This is also a very niche area. Yeah, I may deal in a separate video on this one. Studenthood maintenance requirement, annual uplift. So there is a maintenance requirement for student applicants. This is to all students now. To demonstrate they have funds to support themselves for each month of their course up to 9 months. This level of funds is aligned with the maintenance loans available for home students, which is reviewed every year. This change increases the maintenance requirement to match the maintenance loans available for home students for 25-26 academic year. We will ensure it continues to align with home students' maintenance loans in future. They are going to change the amount as of the maintenance required. They haven't given the amount, but they will change it as required for a local student. We have updated the maximum amount for the accommodation offset in line with the changes to the maintenance requirement. The accommodation offset allows students to demonstrate less maintenance funds if they have paid a deposit for their accommodation. Yeah, this is already the case. Changes to continuous residence rules. Tier 1 entrepreneur and Tier 1 investor are being added to the list of provisions to which Appendix Continuous Residence applies as part of changes to 6A, Part 6A of the immigration rule. The rule concerning the breaking of continuous residence is also being corrected. Small changes. changes to align drafting across immigration rules, small changes here and there. Yeah, so these are all the major changes. The main change that is happening is the graduate route being reduced to 18 months. That's the main one. English language going up to B1 level. That's the second main one. All other are mainly ancillary. What is, just to summarize, yes, mainly it is, and the suitability grounds for family visas, family and private life visas, where their special suitability grounds are taken out and general grounds would apply. So maybe an overseer and all may have challenges applying. We need to see how it comes into practice. What else? Important ones are the same ones. English language graduate route reduced to 18 months. ISC increased. Yes, so these are all the changes. Anyone who has any questions, you can write in the comments. I'll try and answer during, usually come ask during lives. I try to do lives every week. Uh, if you have any specific requirement for your own case, do book a consultation. Link will be in the description. And thank you very much for watching this video. Thank you.